My name is Maury Griffith, and this is my partner Roy Bensbacher, and we are going to walk you through the trust and the will for a single person. I mentioned that at the beginning here because if you are a married couple who've done estate planning with us, this is the wrong video for you. Please stop it right now and call the office and let them know you have the wrong video. Likewise, if you're a couple who has just done simple will planning with us, you also got the wrong video. So this is, again, a video for review of the trust and the will for a single person. Before we get started on the document, I just have a couple opening comments. First, I'd like to be the first to congratulate you on doing an estate plan with our office. As we no doubt mentioned in our meeting with you, having this sort of plan as your estate planning vehicle does a number of things for you. One of the primary goals of this trust that we're about to go through is that anything that you put into this trust will avoid probate at your death. And as we've no doubt discussed, that's going to save you or your heirs a significant amount of money and time and aggravation so that they can administer your estate without going through the probate process through a court. It has other advantages as well. For example, if you become incapacitated, you will have named a backup trustee to manage all the property that's in trust, and you don't have to go to court and have a judge assign someone to do that. It also covers death. So at your death, we've got provisions in here to discuss how to distribute your property and to get it to the appropriate people that you found that you wanted it to go to. And it has other advantages too. For example, we're going to cover a section related to disabled beneficiaries. So you can plan for them as well. So having this trust has a number of advantages over just having a will. And we're going to go through this document now and kind of walk you through what the document says. Hopefully when we're done you have an understanding of what the document is and what it says. And of course, if you have any questions, we've included in your packet some red pens. You can go ahead and write it down on the documents. If you have any changes, write those down, and then when you're done with the video, you can call our office and let us know what those changes are, and we can even set a time to review these with you in person. So let's go ahead and get started. At the top of your document, I want you to look for your trust, and at the top it should say Declaration of Trust of, and then it should have your name there. Please make sure we've spelled your name correctly, including middle initial if you're using it, or middle name if you're using it. And in the opening paragraph here, I'm going to go over this paragraph, and as we get into this document, there's some paragraphs we're going to skip and some of them we're going to review with you. We've kind of picked out the ones we thought would be most important to you and that you'd like us to focus in on more. But if we didn't go over one that you want to talk about, please feel free to let us know and we will talk to you in person about that. The opening paragraph says I, and then again your name should appear. Make sure we have that correct. And then it should say of, and then your address should be there. So make sure we've got your address correct as well. And then you're saying you hereby transfer, assign, and set over to yourself, or it says to myself, as trustee, and declare myself the trustee of any and all property and all investments and reinvestments thereof and additions thereto. And that's called the trust property, which is titled or funded in the name of the trust. So what the purpose of this opening paragraph is to say is that you are transferring your property into this trust, and you are going to be serving as the trustee of the trust. So whereas you're handling things now in your individual name, that property is titled in your name, you make the decisions, you're just going to be putting that into this trust. You're going to be the trustee. You still have full control over it. Paragraph 1 says the instrument is to be designated, and there should be quotations there with capital letters. And again, it should have your name, and then it should say Declaration of Trust dated, and then there should be a blank. Whenever you set your appointment for signing of your plan, we're going to fill in that appointment date right there. So it should be your name, Declaration of Trust dated, whatever the date is of your signing appointment. So it'll be blank for now. Whenever we set that date, we'd ask you to try to keep that date as best you can, because we're going to be putting that date here. We're also going to be putting into your other documents, your powers of attorney, your will, things of that nature. So we'd like you to try to keep that date if possible. If it changes, that's okay too. Just let us know. We'll just have to amend the other documents to cover that date change. Article 2, and it's titled Lifetime Rights. This is the paragraph that discusses what happens with your trust property during your lifetime. And it says, as long as I am able to manage my financial and business affairs and decisions regarding administration of the trust property, the trustee shall pay such part or all the income and principal of the trust property to me, or otherwise as I from time to time may direct. So basically what that sentence is saying is you are in full control of everything that's put into this trust during your lifetime. And that happens so long as you're able to manage your financial and business affairs. Now what happens if you become incapacitated? Well, that's when the next sentence kicks in. It says, if my attending physician states in writing that I am unable to properly manage my financial and business affairs, the trustee shall distribute for my benefit so much of the net income and principal of the trust as the trustee believes desirable for my support, comfort, companionship, enjoyment, and medical care, taking into consideration all other resources available to me. What that's saying is, if at any time your doctor says in writing that you're no longer able to manage your affairs, you're no longer competent, then at that point you've named, and later we'll go through it, but you've named a backup trustee to step in for you and manage your trust. And they're going to be managing that trust as you direct if you're competent. Otherwise, they're going to be managing your property to provide for your needs and your care during your lifetime. Now, the next section you may have, you may not have. In your initial meeting with us, we would have asked you whether you wanted to make or permit your trustee to make gifts if you become incapacitated. And you would have told us either yes or no. And there are some advantages to doing that and some disadvantages, and we would have certainly discussed those with you in our meeting. If you have chosen to allow the trustee to make gifts, then you will have an Article 2B. If you have not authorized the trustee to make gifts, you should not have an Article 2B. So double check to make sure we either have it or we don't have it. So let's assume, for purposes of this video, that you have decided to allow your trustee to make gifts. Then that should start out by saying, if I become incapacitated, so again, only when you don't have capacity, you're not competent. In that case, while you're incapacitated, the trustee may make annual exclusion gifts and tuition and medical gifts for the benefit of your beneficiaries of your trust. Typically that's spouse or descendants. In your case, single person, it's going to be probably descendants. So that's what it should say there. Now, what is an annual exclusion gift? Well, you're authorizing your trustee to make an amount of money as in form of a gift to any one person, not to exceed the limit that the IRS sets on an annual basis. So each year the IRS comes out with a dollar amount, for example, $13,000, and they say you can give that amount of money to any one person each year. So you're saying to your trustee, if I'm incapacitated, trustee, you can go ahead and make those gifts limited to that amount each year. You can also make tuition and medical gifts, and those are just what they sound like. Trustee, you're not limited to that annual exclusion amount, but you can make gifts to any one of more of my descendants or my beneficiaries for tuition, qualifying tuition purposes, and qualifying medical purposes. And again, the IRS sets the definition for what qualifying tuition and qualifying medical expenses are. So if you, again, allowed gifting, that Article 2B should be there with explanations of what annual exclusion means and with explanations of what tuition and medical means.
Maury, we might add, it doesn't have to be in money. It can be, a lot of our farming clients like to give interest in real estate, so it's just in value.
Right, that's a good point. To the extent you don't have a lot of cash and you have a lot of farmland that you want to start gifting, and one of the reasons you might gifting is to start reducing your estate value for estate tax purposes. Your trustee would be authorized to start making gifts of real estate as well. The next paragraph is entitled Death Provisions. And this provision kicks in, obviously, upon your death, and that first sentence there says, after my death, the following provisions shall apply. So anything prior to this that we've discussed is during your lifetime. So what happens while you're in charge, the trust is for your benefit, and if you become incapacitated, the trustee is to manage the trust for your benefit and may or may not be able to make gifts. After your death, Article 3A says, the acting trustee may provide for all of, and there's several categories, or paragraph A1 is all of my debts, and 2, all the expenses of my last illness and funeral and of the administration of my estate, and in 3 there, the estate, inheritance, and other succession and death taxes that may happen as a result of my death. So you're saying to your trustee, upon my death, trustee, I know I'm going to have some debts and expenses. You have the option of going ahead and paying those. After you pay those, trustee, I want you to ratably apportion, and that's where we're getting into Article 3C, those expenses amongst my beneficiaries. And we think that's the fairest way to handle the payment of these debts and expenses. It's not that your beneficiaries have to come up with money to pay them, it's just that their shares are going to be ratably reduced in order to cover those expenses. So for example, let's say you had 2 beneficiaries and you left one beneficiary 60% of your estate and one beneficiary 40% of your estate. You're saying to the trustee, you're responsible for handling my debts and expenses, and to the extent you pay those, reduce those trusts for those beneficiaries ratably. So 60% of those expenses that you paid are going to come out of the 60% share, and 40% are going to come out of the 40% share. Now you can do expenses differently. You can just say everyone shares in the expenses equally. We don't think that's necessarily the fairest, but if that's the way you want us to write it, please just let us know and we will reword this language. In Article 3E, there's a provision that talks about, well, I'll just kind of read it to you. The trustee shall distribute out of the principal of the trust property any cash, gift, or other specific bequest or devise made by my will or any codicil thereto, to the extent the trustee determines that such gift, bequest, or devise will not otherwise be set aside in full, and in the case of a specific bequest or devise, the property so bequeathed or devised is an asset of the trust. So basically you have this trust that deals with what happens to your property at death, but you also have a will that we're going to get into in a minute. And sometimes we put certain gifts in the will. For example, maybe you've decided to leave some money to a charity. Oftentimes we will not put that in the trust, instead we'll list that in the will. What this provision says in your trust says, if I've made a specific gift in my will, trustee, if the executor of my probate estate doesn't have any money, which is probably going to be the case if you get everything funded into your trust, then you can go ahead, trustee, and pay that gift that I've made in my will. Even though there's not enough money over here to do it, you can go ahead and satisfy that gift. So now I'm going to turn it over to my partner, Mr. Bensbacher, and he's going to go through the next section of your trust.
Now, Maury's taking you through what happens during your lifetime and some of the things that happen upon your death. That is, taxes are taken care of, debts are taken care of, funeral expenses, that sort of thing. And once all of that is done, once the smoke has cleared, so to speak, you're going to have the balance of your trust estate. What remains after your lifetime and administration of your estate. Typically, single individuals, married individuals as well, but we're dealing with you single individuals, you're going to leave it to children, grandchildren, nieces, nephews, or other beneficiaries. For the sake of my explanation, I'm going to assume children. And in Article 4, or the provision that's entitled Trust Estate, if you find that in the draft that you have, you'll be up with me and we'll start from that point in the trust. And it's setting up trust for the beneficiaries, for the children or the nieces or nephews or trust beneficiaries, as I said. And it's going to be equal trust or unequal trust as you've dictated to us, your instructions. And oftentimes we'll say, if one of these beneficiaries has predeceased me, it'll go on to their descendants. That's what's known as a per stirpes distribution. So we might cover 2 or 3 levels of beneficiaries in order to cover that event of a beneficiary dying before you or after you, but before they take things out of the trust. And then the next section would be entitled Children's Trust or perhaps Beneficiaries Trust, and that's going to give the beneficiaries or your children rights in the trust that you have the trustee set up for them. Initially, if your children are mature enough, you think they're able to handle it, you're going to say, my child can withdraw. They can take income out, they can take principal out, whatever they so desire, they can take out of the trustee by giving written notice to the trustee. If your child is not able to handle it, you may restrict it by age. For example, my wife and I have said that our children can't withdraw their share from trust until they reach the age of 45. So they're restricted to that point, but the trustee can use income or principal for their benefit, their health care, their medical care, their dental care, their housing, their educational needs, that sort of thing. So it all depends on your specific situation and what you've dictated to us as to what you're going to find in that particular portion of the trust. Now, we have to think through the idea of a beneficiary dying after you and after the trust is set up for them, and before they've taken the trust out of your trust, their trust out of your trust. And what you're saying is, after taking care of debts and expenses in their estate, like funeral expenses, death, taxes, that sort of thing, you can leave it trustee, however they may have provided in their will. Now, we want to caution you, and you caution your children or other beneficiaries, their will must make specific reference to your trust. So, for example, if they have a will that says, I leave the rest and residue of my estate to my wife, it won't necessarily pick up their interest in your trust. They have to specifically say, I'm leaving. It is my intent to leave my share in this trust that my mother set up for me, my father, my aunt or uncle, whatever it might be, to whomever. Now, we also go on and cover with you the provision of a child or other beneficiary dying that they don't write a will. And you might have decided, well, if they die before me, it goes to their children, again, their descendants. You may say it lapses, in other words, that share is no longer created and it increases the share of the other beneficiaries. So again, it's per the instruction you have given us. You're merely giving instructions to us so that we can get them on paper for you in this trust so that it directs your trustee as to what they should be doing in the event of your death and after expenses are paid. At that point in your trust, you're going to find a section or an article called administrative clauses. And this is a set of general instructions to the trustee as to what happens in various incidents. Letter A typically will say, property that becomes distributable to a beneficiary that already has a trust under my trust, the two shares can be added together. So let me give you an example just so it's easier for you to understand. Let's say in my case, I leave shares in my trust to 4 sons. Each of them have a share. And one of those sons of mine dies after the trust is created for them and before they take it out, with no children who survive them. Their share then will increase proportionally the shares of the other 3 sons. Well, the other 3 sons, each of them are already going to have a trust, so as this share of the deceased son comes over, you just merge it. It's just an ease of administration. It's easier for trustees rather than keeping 2 independent shares for the same beneficiary. The next provision that I want to discuss with you is probably letter B under the administrative clauses. And it has to do with the death of a child or beneficiary while a trust is being held for him or her. And typically what clients will try to guard against is the distribution of that trust of the deceased child or deceased beneficiary to someone who is a minor or maybe not really able to handle it. And they'll do that by restricting it by age. They'll point out an age, and for sake of example, let's say 25 years. So 25 years of age, you can have this trust, but if you're less than 25 years of age, it's going to be held and managed for you and protected for you by the trustee. This is you talking to the trustee and to the beneficiary. I want it protected. You can draw money out for your welfare, your support, your maintenance, your education, dental care, the necessities of life, but you don't have full control of it until you reach the age of 25. Sometimes clients will go older, sometimes clients will go younger. That's totally up to you. So you may find an age there if you've already given it to us. Some clients want to think about this, so you may find a blank. The next provision, item C, has to do with your trustee being in a position where the trustee is to pay out income and or principal, but for some reason the beneficiary, the trustee believes, is unable to handle that distribution. They may have been in a car wreck and they're in the hospital in a coma. They may be minors, that sort of thing. They just can't handle it. You're saying, trustee, in that particular situation, you can pay it out to the legal guardian of the beneficiary to be used for their best interest. You can pay it out to a relative or friend of the beneficiary to be used for the beneficiary, a custodian that's appointed under Uniform Gifts to Minors Act, or you can make direct expenditures. Now, trustees typically like the 4th provision, the 4th option, that is to make direct payments. So there's a medical bill, the trustee writes a check to the medical care provider. That way the trustee can't be questioned later, isn't going to make a move that the beneficiary finds suspect. So they may very well be operating under that provision. The next clause is sometimes called the spendthrift clause. It's not an always protection, it's not a guaranteed, but we put it in, we think it's definitely a deterrent. You're saying no interest in the agreement. Again, you're talking to your trustee, you're talking to the beneficiary. If you have a trust under my document, trustee, you're not to let the beneficiary assign it, put it up for collateral. It can't be taken in lawsuits, including claims for alimony or maintenance. So it protects it. As the law has expanded over the years, if your beneficiary has the absolute right to tell a trustee, I want it, this may not give you a whole lot of protection, but it does deter individuals from putting it up for collateral, or maybe even someone who is suing them from coming after it. Now, we believe, and we feel the law supports us, that if there's some restriction, like the age that I've discussed, if you put an age restriction that a beneficiary can't have the trust until they get to a particular age, that probably is a guaranteed protection. But in any event, you may want to discuss that with us. It can be an important provision in your trust.
Roy, before you move on, can the person who's watching this video, the initial trustee, the person who's creating the trust, use this provision to protect the trust for their own medical, Medicaid or something?
Very, very, very good point. And a lot of clients are under the misinterpretation they can. If you can direct this trust, if you're the trustee of the trust initially, as Maury indicated when you set it up, it's something that you own, it's something that you create, it doesn't give you any protection at all. Someone else has to set it up for you. The next provision, probably letter E, it says something about 21 years after my death and all my beneficiaries. I just simply want to say we're satisfying a law in Illinois. It's called the Rules Against Perpetuities. We have a law school class about that. Probably not something that you're really wanting me to go into in this video, but suffice it to say we are satisfying the state statute. Next clause, letter F, is talking about people acting in a fiduciary capacity under your trust. And simply stated, that's your trustee. If your trustee becomes unable to properly manage the trust as determined by a doctor, they're not serving as trustee anymore. And that's where it's important, and Maury will talk about this a little bit later, but it's important to you to have named a successor trustee, because this may apply to you. So it's very important that you realize that's a fail-safe that we put in to keep the trust from being mismanaged by someone who's not competent to manage it. The trustee shall send a written account. That's talked about in the very next section of the administrative clauses. This is very important, and particularly with regard to those of you who have appointed individuals as trustees. Hopefully any professional trustee would know this rule, that they have to send out an accounting, but it's something that we would discuss with your trustee, or you can definitely share with them. They have to send out accounts. What money did I take in? How did I spend that money? What money did I give out to beneficiaries? That has to go to any current beneficiary of the trust and any future beneficiary if the trustee so desires to do so. This is very important. It's a requirement. The beneficiaries are entitled to know. Now, next clause kind of ties in with the trustee's rights and duties as well. Before a trustee distributes, if they're owed money, if your trustee's owed fees, reimbursements, if it's a professional trustee and they're owed their fees, before they make distributions, they're entitled to be paid. They're entitled to withhold that if they're not being paid. And if they have a dispute with beneficiaries as to whether or not they should be paid, any legal expense that they incur in order to get awarded their fees, that's also going to come out of the shares being distributed. So trustees have to be protected. They're taking on a job for you here, and you want to give them some protection. You also want to protect your beneficiaries, thus the accounting and the right in the trustees to get their fees. Next clause in most of our documents, not all of them, but in most of them, has to do with adoption. Your children, your beneficiaries, their descendants, if you've included them, if they adopt, do you want those adopted children in as descendants or not? Do you want only naturally born children, bloodline children to be in, and excluding adopted, or do you want legally adopted children to be included? That's a decision you have to make. You're not required to go one way or the other. Now, it does not speak of stepchildren. We get that question all the time. If you want stepchildren to be involved, to be included, you have to specifically state that, and you should please be aware of that and advise us to do so if you want to include them. Some clients, not all of you, will have a clause called disaster clause that comes at this point in the document. And a disaster clause is sort of what the name implies. That's when you and all of the beneficiaries you've thought of don't exist. So you picture having a family get together and there's a tornado and it kills you and all your beneficiaries. So now Illinois is waiting to take over for you. You say, wait a minute, I don't want that. And you've given us instructions that say, in the event of such a disaster, this is where I want things to go. I don't want Illinois to decide. I want to decide where it goes. And we almost always recommend this in the case of a small family. You have you and a couple of your children, or you and a child that has one grandchild, one child for you. That's a situation where you probably want to consider a disaster clause, and oftentimes we see charities at that point. So it's you deciding as opposed to Illinois. And Maury, I think that brings you to the Special Needs Trust.
Sure. The next provision we're going to cover is entitled Special Needs Trust, and it should say that at the top of the provision and should be underlined. The Special Needs Trust provision is designed to cover beneficiaries who are either they have a mental disability or a physical disability, and specifically it's designed to kind of protect that beneficiary's share from the claims of public aid, nursing homes, things of that nature. If you have a beneficiary who's disabled now at the time we're doing this planning, please make us aware of it, because we're going to need to discuss with you whether you want that particular beneficiary's share to be included or not included within these special needs trust provisions. For example, you may have a beneficiary who's got a slight disability, and you don't want them covered under this provision. You want to make sure they get their share outright. And sometimes you'd make that decision based on whether or not that